Go. Welcome to day 2 of the Global Hope Contest. Good morning and welcome to day 2 of the Global Hope Conference. Today we have a great slate of presenters, and we're starting off today with Dr. Justin Wood of Phlox ADR and the founder of the Great Plains Mediation Group. And today he's going to be talking to you about ethical considerations in arbitration and in ADR and ODR, which is a very important subject because ethics is the heart of conflict resolution. And with that, I'm going to turn it over to Justin.
Thank you, Chris. Thank you very much. Hello, everybody. I'm Dr. Justin Wood. I'm the president of Phlox ADR again, and I'm the founder of Great Plains Mediation Arbitration Association. We call it GPMAA. I'm going to be sharing with you today this topic, which may be very dry and boring to some, especially if you're not into arbitration. Then again, if you are into arbitration or you're thinking of getting into arbitration, this is one of the foundations and keys that you need to know about arbitration, because most arbitrators get in problems with their ethics. It's not normally about what they've done right or wrong, how their decisions are made, that they normally fall into problems. They normally fall into problems with their ethics. So I'm going to get started here. Here's my little bio. I always include this so anybody can look it up if you want to see who I am. I'm a distinguished mediator with Texas Mediation Credentialing Association. I'm a superior mediator and arbitrator with GPMAA, as well as several other organizations, including that I'm a court mediator in multiple states. I have a background in both IT, including programming and AI, as well as a construction background. Let's get started here, okay? What is online dispute resolution? ADR is what we call it. It's any dispute resolution model that takes place, whether in whole or in part, in physical, in-person means. This can be an office, it can be a complex. I do a lot of church mediation, so we do those in auditoriums or church buildings. Any business you go to, this can also be your in-person, upfront, personal contact, which is ADR. ODR is just the opposite. It's any mediation or arbitration that takes part in part or in whole or in part away from each other, such as phone or fax, email chat. Brave uses an IoT system. Then again, video conferencing, like we're doing here, is very common. So we're separated. The thing I like to mention here is we also have a hybrid system. There are many arbitrations that I've handled to where I have one party in the room and the other party, or even witnesses, maybe on video conference. So not only do you have ADR where you're together, everybody's together in the same room, or ODR where everybody is virtual, you can also have a mix and a combination. And that's going to be some of the issues I'm going to be talking about today, because in arbitration, this brings up a lot of ethical problems. The major differences in mediation and arbitration come into the discerning the differences, okay? The biggest discerning difference is in mediation, you're working to an agreed resolution, okay? So you're gonna work together, you're gonna find a way to find the solution to whatever the problem is. In arbitration, the decisions are made by the arbiter, okay? They're gonna make the final decision. They're gonna make whatever ruling or award that's gonna be upheld or gonna be dealt with by the people. In mediation, we have private conference. So if things aren't going well, if something needs to be discussed, if the mediator needs to step out and say, hey, to counsel or to a party, you know, we have an issue, we have a problem, something's going on, you can do that. In arbitration, there's absolutely no ex parte communication whatsoever. So the arbiter is never alone with a single party, and they're never able to talk, whether that is in a fax, an email, a phone call. That is always an ethical breach. Mediation, again, is very informal. It has been so informal that with some of the court hearings I handle, that people show up in tank tops and shorts, okay? In arbitration, it's a lot more formal. You have rules to follow, you have guidelines to follow. things have to be done in a certain order. Again, in mediation, you're back to when you come to an agreement, you have an agreement. You have a contract, okay? And that's what the agreement is. It's a contract. The party saying, we will do X, Y, Z, okay? It can be upheld in court. That's up to the parties. If there's a breach, you show it to the judge. Judges are very willing to uphold mediated agreements, okay? In arbitration, that's completely different, okay? When you're given the award in arbitration, that can be taken directly to a judge without a court hearing, possibly, and turned into a judicial court order. So the difference is quite vast. Both of them do have to have judicial approval to be upheld, but then again, the award from an arbitration can go straight to an order. What is an arbiter, okay? Well, now it's gonna jump up here a little bit on me. Go back one. An arbiter is an individual or a panel of individuals. Many times, arbiters are not a single person. They can be 3 people, 5 people, 7 people. I've seen them as high as 15 people, which is quite rare, but does happen. They're there to be the private judicial panel for the parties to render an award based upon the arbitral contract. Now, that's the important part. An arbitrator is under a contract by the parties to make an award. Okay, the parties have agreed they're going to abide by what the arbiter has come up with. This is all created either from the contract that they originally signed or by ad hoc. Ad hoc means there were very little rules, very little organization in the contract originally, and the parties actually sat down together in a pre-hearing conference and hammer out those details. This can be how many witnesses are we going to have? How many documents are we going to have? Are we going to send documents via email? Do all documents have to be printed? There are many arbitrations to where the parties want to see physical handheld documentation, not PDFs or anything of that nature. There's a lot of other subtleties in arbitration, as in investigations into hardware, software, that kind of thing, emails, to get this information. Arbitrators, this is a very important part that arbitrators fail to understand sometimes. An arbitrator does not have enforcement power. You can stand up in front of a judge in a court hearing. You can cuss him, slander him, whatever you want to do. You're probably going to go to jail. That's not going to happen in arbitration. We don't have that kind of power. The other thing is an arbiter does not have sanctioning powers. So if you're late turning in stuff to a judge, many times a judge is going to hit you with sanctions, which can be monetary mostly. They're going to hit you with a fee. They're going to hit you with possibly jail time. There's a way for a judge to hold you accountable to do things on a certain time scale. On arbitration, unless it's written into the agreement that the arbitrator has some type of sanctioning powers, and again, those sanctioning cannot be going to jail or anything of that nature, then the arbitrator could only do maybe a monetary award or something in a secondary, hearing. Arbitrators do not have enforcement power. They do not have sanctioning powers. What are the bias concerns when we get into arbitration? And I'm going to talk a lot about bias concerns today. The initial part that we run into is disclosure. And before any arbitration ever gets written, you should have disclosure, okay? This is one of the key elements to arbitration because you want a fair hearing. Relationships, there cannot be any relationships. A lot of people say there can't be any personal relationships, but in arbitration, it goes much, much further than that. In mediation, you can get away with, well, you know my cousin, and that can be disclosed and agreeable to both, all the parties. In arbitration, that's not right. You can't do that. The people can authorize it and say that's okay, but normally you don't want to do that. You want to have no family associations, no personal associations, no business associations, anything of that, any third party associations, okay? So if I knew your cousin or your brother or someone else you worked with, this may be a time when an arbitrator says, this is not a case for me. I need to pass this off to somebody else. I need to step away. No one is ever upset at the arbitrator until the final award is made. That's when all the disagreement comes out to be. And then they start replaying in their head, what did the arbitrator do? Or what did the other party get to the arbitrator that I wasn't part of? And that's where all these come into. A lot of people will get into the disclosure of where do your family work. I was party to an arbitration, and they came out that my wife worked at the same place where one of the parties' wives worked. Well, that is too close because anything can happen. I know a friend that got in trouble with went to a certain restaurant all the time, and he frequently ate there. Well, there was an arbitration, and they asked him to be the arbiter for that case. Now, he was no part of the case. He just happened to eat there at that restaurant, and that restaurant had an arbitration that came up. A few weeks later, it came to being that after the other party had lost the case, he was eating there, and whether it was a dirty cup was given to him or whatever, the business manager came out and said, I'm telling you what, I'm going to comp your meal. That came back a few weeks later as the other party gave him free food for the arbitral award. So you have to avoid these situations, and many arbitrators get in problems with this. If there's any type of personal business, any type of relationship, that's where an arbitrator needs to stop talking themselves into a job and walk away. Any party knowledge, if I'm familiar with the business, if I'm familiar with the parties, you just need to walk away. That's not a place to be. And most times your parties will do that for you. You won't have to make that decision. Procedures, okay? If you're too lenient with one party, in other words, let's say that the plaintiff party says they're not ready and they need 3 more days. And you say, okay, that's fine. 3 days later, you come back and you hear, well, I need another 2 days because we couldn't get something, and you give them another 2 days. Well, now you've got 5 days you've given them extra. And then the defendant party comes up and says, hey, we need an extra day. And you turn around and say, no, you can't have an extra day. We've already had 5. You're going to get into a problem of showing partiality there because you gave one party 5 days and this party asked for 1 and you said no. Yes, they should have had their stuff together, but then again, you need to balance that and make sure that you're not showing favoritism. Same thing with being too stringent. That happens if they need 2 days and you don't give them 2 days, then they view that as you favored the other party because it hurt their case because they needed those extra 2 days to get something together, or they couldn't get access to something. That again is all based on your arbitral contract because you have deadlines in there you have to meet. If there's too much involvement, if the arbiter is asking, an arbitrator can ask questions, both of the witnesses and of the parties. But if there's too many questions, that runs into a problem because you can't put on their case, they have to put on their own case. So an arbitrator can get in a lot of trouble with saying, what about this? What about that? How did this work? How did that work? How did this go? How did this come about? If the other party's not asking it, that's not the arbiter's position. The arbiter is just supposed to be clarifying questions, not putting on a case. Too much or too little technical knowledge. This has gotten me a couple of times. Because I have a construction background, I'm called into construction disputes. Well, sometimes I have too much knowledge in construction, and one party feels that puts them at a disadvantage. Then again, I could have too little knowledge a few times that they didn't think I would understand it, and it put them at a disadvantage. So an arbiter kind of has to balance that out. You have to kind of be a middle ground person. Opinion on a case. If you've ever, let's say you had a car wreck and the guy that caused the 5-car pileup was drunk, and you got on Facebook or Twitter or something and you tweeted out and said, hey, I believe all people who are drunk drivers need to be locked up for 10 years. And later on that becomes public knowledge. Somehow somebody was researching your back history and stuff and comes up, and the party that lost has several DUIs. Then again, that could come up and say that you had a knowledge of that person, and therefore you were biased against them. So you have these types of situations you need to be very careful with. Communication, again, too much, too little communication. You're talking too much. You're allowing one party to talk too much. If they've got a deadline and say that they have 1 hour for a cross, and you're giving them 1 hour and 15 minutes, but you hold the other party to 1 hour, again, you're getting into a biased situation. Private communication. I don't know how to stress this enough. Absolutely no private communications. Arbiters, I tell my people when I'm training them, or if I'm working with somebody, I tell them, you drive into the parking lot and one of the parties is standing in the parking lot, don't get out of your car. Stay in your car. Drive to the other end of the parking lot. Go get a coffee. Go do something. Don't get out and walk into the building with a party. Walk in with both parties is fine, but never walk in with one side. The same thing goes with restroom breaks, and a lot of arbiters do this. If you're at a hotel or something of that nature, and you're going to have a bathroom break. Some arbitrations are an hour long. Some of them are 4, 5, 6 hours, or even days or weeks long. So let's say you're at a hotel. If I've got a room rented, I'm going to go to the restroom up in my room. If I'm going to eat, I'll go to my room and have food brought up, or I'll leave and go to a different restaurant. If you happen to go to the restaurant and a party comes by and says, hey, could I sit down and join you? The answer is no. Because any type of private communication in arbitration can get you in trouble. A mediator can sit down in the foyer before, because one party gets there early, and they can sit down in the foyer, drink a cup of coffee, drink a glass of tea, talk about the weather. As long as they're not talking about the case they're mediating, you're fine. An arbitrator cannot do that. You cannot have private time with a party. The least amount of time, the better. Anything can be seen as a possible way of colluding or bribery or anything of that nature, and that just has to be avoided. A word outside of the scope, okay? A lot of times in construction arbitration, we get called in and we can go to on-site arbitrations, to where we actually go there physically and say, okay, let's look at the concrete. You say the concrete's damaged and it's not poured right. Let's look at the concrete. Then the arbitrator can't look over and says, well, that beam is not installed right, and those bolts sitting in sitting on the side that have been put in the concrete are at an angle that's incorrect. If that's not part of what the party's presenting, that's none of the arbitrator's scope. So you have to leave it alone. You have to be quiet. That's not your problem, because again, that's putting on their case. If they don't bring it up, it's not the arbitrator's case to bring it up. Assuming things, which is a big problem with arbitrators. Arbitrators get into problems when they're writing their award by assuming certain things happened, or assuming certain things went a certain way. You can't assume in your award. You have to say, this is what I was told. This is why I made my decision. So bringing in facts that were not presented in the case, it's a big thing in arbitration. If it wasn't presented in the case, you really can't include it in your award. Let's get into some specific biases, forced biases. These happen in arbitration all the time. An intentional argument. I've had parties intentionally argue with the arbitral panel just to see how we're going to handle it. If we give them leniency, then we could be showing bias. If we come out too strong, well, then were we favoring the other party? So an arbiter spends a lot of their time balancing in their mind, how are they perceived? Overreach and bias, again, I'm conducting how they present their case. A failure to comply. If a party refuses to comply, again, an arbiter does not have enforcement powers, okay? So the party that's being damaged has to go to a judicial court, file a motion, and say, hey, they're not complying with the arbitral contract, and I want it enforced. The judge will have a hearing, the judge will give a ruling, and then we come back to arbitration. That's something the arbiter cannot do. There are a few cases where you can write that in a contract, but I'm not getting into that. Witnesses. An arbiter cannot have a relationship with the witness. If they're bringing in your brother, cousin, uncle, friend, neighbor there's a problem with you and that witness, and the arbiter may need to think about walking away from that case. All this needs to be disclosed. Any witnesses, any parties, any companies, any insurance needs to be disclosed in the very beginning of arbitration. Again, no ex parte communications with the witnesses. I can't sit down with the witness and talk, just like I can't sit down with the parties. I can't sit down with legal counsel for a party. I have to, everybody who's involved in the arbitration that's part of the parties, I can't sit down with. Only the panel or the coordinators can I have a private conversation with. Again, over questioning. Third-party relationships or no opinion on a party. You know, you have to base yourself on what's going on, and again, keep those lines. Contractual overreach, outside of your scope, your case authority. If you've been told that the case is going to be awarded somewhere between $30,000 and $80,000, and you give $150,000 award because there were, let's say there was a car accident, but there were a lot of bills presented for medical bills and damage and physical therapy, but they were not part of the arbitral contract, you cannot award on that. That is outside your scope, and that is a bias. So that case is going to get thrown out of a judge. When it's brought up in front of a judge, it's going to be thrown out. The one thing that cannot happen to an arbiter is to get overruled by a judge. That is almost a death sentence to an arbiter. Because if a judge deems that you've done something improper, anybody else, any other arbitration you have, that then they see that and you need to disclose that, when they see that, they're going to be saying, hey, this guy doesn't know what they're doing, or this lady doesn't know what they're doing. They're going to be questioning everything. If they feel that their case should have been won and they lost, then again, there's going to be a lot of questions to you ever being an arbitrator again. So I can't stress enough by balance everything in your head. We have unconscious bias, okay? Situational or personal issues, okay? You may not see it as a bias, but some people look at people differently. I had an arbiter that was sitting on a panel one day, and every time this woman talked, which she had tattoos all the way down both arms, and every time she talked, he kind of turned up his nose. He didn't realize he was doing it, but then again, she felt slighted. Several of the other people kind of felt that way too, because his tone with her was more harsh. Whether he didn't like the tattoos or whether there was one of the tattoos that was causing him a problem personally, it was still an unconscious bias. And that was brought up to overrule the arbitral panel because he acted differently to her than anybody else. The type of conflict, again, if you've made a statement on Facebook or Twitter or something about a specific type of conflict, then you need to be careful about talking yourself into sitting on that arbitral panel, because it can come back and bite you. Attitude, persona, same thing. If you're snippy to one person, you can't be snippy. You can't not be snippy to the other person. You have to be the same to both. Award wording, again, in your award, you have to be clear. You have to be precise. You have to be. There could be no middle ground. You can't be assuming. Well, they said their car was hit from behind, but it does appear it was hit from the side, but I still award. No. How did you come up with that? How did you come up with it was hit from the side? Where was that information given to you? How did you come up with that? Those can be very important. And there's 3 types of awards, and we're not getting into that today, but based on the award, based on how much information you give and the type and the way the information needs to be written into the award. Perceived biases, okay? Matching personalities or unmatching personalities are a big issue in arbitration, okay? If somebody tells a joke and you just seem to find them funny, but the other side tells a joke and you didn't find it funny or didn't even laugh, again, it's going to show a bias. It's a perceived bias. One side's going to perceive that you like or dislike the other side for some reason. You have to, down there, 2 more down, poker face. You have to have a poker face. If you're going to laugh, always laugh. If you're going to smile, always smile. I try not to ever laugh at a joke. Some people are just inherently funny. There's nothing about that. I've had some people in arbitration that it's really hard not to laugh because of the way they are. They just have a funny personality. You have to put into your head, if you're smiling at them, are you smiling at the other side as well? Because that's going to cause you a problem. It's the other side's going to perceive that you like them based on their personality. And then again, word language association, any type of thing that people can connect dots to, they are. And I can't stress enough, in your initial pre-hearing conference, you put everything on the table: where your children work, where you go to church, what gym you use, where you go shopping, any associations you're part of. I'm actually a member of the American Bar Association, and I had a party that had a problem because I'm a non-attorney, yet I'm a member of the American Bar Association. They had a strong issue with that. Had I not brought that up in the pre-hearing conference, again, because of my association with the American Bar Association, that could have came back and said that, there was a bias there, or that I awarded because the other party, and I didn't know this, was a member of the American Bar Association because they were a paralegal. So you have to disclose everything. I can't, I go in there and almost lay my life out, in paper and documentation, because I don't want anyone to think there was anything I was trying to hide. And the arbiters I see that do the best do that. They make sure there's no perceived bias, there's no applied bias, there's no connection whatsoever. And if there is, it's so minute that it's almost unconscionable. Even what college you went to, or colleges, you just have to do this. I can't stress it enough. It's one of the things that most arbiters fail at. Something that gets real interesting is when we get into presenting parties. In a court case, who's going to present the case? Well, normally it's per se, meaning you are. It's your case. The damages happened to you, or the situation happened to you. A few cases you can have, a power of an attorney or something of that nature that allows you to speak on behalf of someone else, but they are limited, okay, on what can happen when the situations and everything else. Or who else can present for you? Legal counsel. Legal counsel can always present in a court case. So, but in arbitration, that's different. Okay, again, arbitration is not a court hearing, even though it's it's quasi-conducted as such, because the arbiter or the arbitral panel will be sitting on a perceived bench, okay, above the people. Normally it's just a table, that's all we use. We don't wear black robes or anything of that nature. And we let one party speak, we let the other party speak. We control what documents they present, when we have objections, if they've not been waived, these type of things. So it does seem like a court hearing, but it's really not. The thing we get into is a party can put on their own case, just like in court, per se. Then we have family members. A party can elect to have their family member present their case in arbitration. It happens all the time. They don't feel that they can present the information well enough, and they'll have a family or somebody else present that for them. So let me clear something off my screen. Then again, business partners, employees can present a case in arbitration, and that is very common in the business industry, to have some either a manager or a supervisor or it doesn't have to be the actual business person that had the problem. It could be almost anyone. So I've had department heads present their case in arbitration for the company, and that's not uncommon. Insurance personnel commonly present cases in arbitration. It's not uncommon at all to have an injured party, whether it be a car accident or slip and fall or anything of that nature, and have the insurance person be party for the insurance company, and have a family member present on behalf of the person who is injured. And the person who is injured may or may not be there, but they have to have the facts of the case. Attorney and counsel, again, will always be allowed to present arbitration because they're hired counsel. That's their job. NARs. Here's something that a lot of people, especially if you're not familiar with arbitration, may get a little freaked out about. A NAR is a non-attorney representative, and they're quite common in arbitration as well. This is someone who knows arbitration and how to handle a case. This can be anything from an ADR professional to a student attorney. It could be someone who's just well versed in how cases work and how the information needs to be presented. It can be a student who's passed the bar, passed the law school, but just never passed the bar. There are several different things that a NAR can be. And simply all they are is they're a professional person who presents a case in arbitration, but they're not an attorney. There's even organizations set up to be members of that. So that is sometimes wigs people out a little bit in arbitration because they're not used to people presenting their own case or having someone present their case for them. But again, arbitration is not a court hearing. So those things are allowed in arbitration. Issues we have when we get into either hybrids or ODR. In ADR, our ADR arbitrations, we're all in the same room. We take a break together. We know when, somebody needs to step out for a minute, we can all walk off. The arbiters normally, again, you can't have private time. So let's say a party has an issue, they need to use the restroom, or they're having a medical problem and they need to step out. Then the arbitration panel or person can just say, hey, we're going to take a break. The arbiter needs to go elsewhere away from the parties, and the parties take their break. That's simple. How do you do that in ODR? I'm just going to pause there for a minute and let you think about that. How do I allow a break in arbitration like that? Because not everything's announced. So what happens, we talked a little bit about early arrivals and ex parte communications. The same thing happens if you're entering a building. You can't enter a building with a party if you're the arbitrator. The same thing is you can't bring up your Zoom webinar, okay, and allow a party to enter the arbitration webinar early and you having conversations with them, whether you have conversation or not. You can sit there silently. The other party does not know you were sitting there silently. So there's your problem. So you need to have a coordinator. We have arbitration coordinators is what we use. And what they do is they literally are in the room, in the Zoom meeting room, and they're waiting for the parties. Once all the parties are there, the arbitration coordinator will come out and will drag us from a room we're by ourselves and drag us into the arbitration hearing. Whether it's one of us or a panel of us, they can just drag us all in there. Or they wait till everybody and then call us and tell us, okay, now you can log in. Both parties are present or both counsels are present. So having an arbitration coordinator is a must if you're doing ODR, arbitral hearings. What if you have a drop signal? Again, there's another problem. You're having ex parte communications. So again, that's where the coordinator comes in and just stops the arbitration and says, whoa, stop. I'm sorry, we've lost one of the parties. Their screen has went blank. So let's stop right now and grab the arbiters and move them to a private room or log them off. If you're using an IoT, then just log them off. And then the arbitrators have to come back on after they're told to reconnect. I can't stress that enough. I've seen several arbitrations in the last few years that have went badly because of a drop signal. And 20 minutes went by. Now the other party, when they lost the case, started arguing what was the arbiter and the other party discussing for this 20 minutes I wasn't on here. So a coordinator is very effective in helping you in arbitration. Muting and unmuting. You need to have an IT professional or somebody who kind of knows the system around, because if they're speaking and you can't hear them, you can't conduct your hearing. Same thing as if you're speaking and they can't hear you, again, you can't conduct your hearing. Missing documents. You just can't start without them. Just delay. I hate delays in arbitration because it draws out the process, but you should know about that before the hearing, and then you can make your determination of whether you're going to give a stay or you're going to give an extension of time or what you're going to do, or if you're going to move forward. I really don't recommend moving forward without proper documentation because all it is a problem waiting to happen. So just don't start without your documents. Technical knowledge. We actually have our arbitrational coordinator go out there and help them build, whether it's a PowerPoint or put together their PDFs, in a limited fashion so that they have it. They also pre-run it with them. So if the party's going to present their case, they're not always attorneys. They're not always, technical people. So the coordinator helps both sides do that. They're not part of the arbitral panel. They have nothing to do except bring the arbitrators in, or kick the arbitrators out, or help the parties put the paperwork together. That really helps the parties get things together, especially when you're dealing with pro se people, or if you're dealing with a NAR that may not be familiar with a system, or is having problems getting things together. It's just so much helpful because they cannot ask the arbitrator, hey, how do I put this together for you? That's something an arbitrator cannot answer. That's where a coordinator comes in. They can pre-run it with them. They can help them out. They can give them any guidance they need, and get some information if it's warranted. Panel, and it really a lot of problems. So I can't stress having an arbitral coordinator enough. How do you set up an ODR arbitration? You just pick your software, whether you're using Zoom or Adobe, JoinMe, whatever that you want to use. Know your important functions, the chat features, the caucus areas, the captures. You have to know how those things work in the they call them private rooms and stuff like that. And again, the arbiters can go out to a caucus themselves and step out and have discussions, but not with the parties. You can't be chatting with a party. That you just can't do that. You can't let the parties be chatting with you. Again, that's where the arbitral coordinator helps. You've got to know your security licensing. If you're using something like Skype or things of that nature, which are good software, they are not private software. So anything you put on there, the company can record or a third party can record. You also have to prevent the parties from recording sessions. And that's one thing like Zoom and Adobe really help out good on, is they alert the host if someone's trying to record in most cases. They also have to sign in their agreement that they're not going to allow recordings. So this is very important. You have to know what your software license is for, how it works, and are you secure? Not broadcasting live, because arbitrations, just like mediations, are private and confidential. Get into creating some moot hearings, control the flow, how it works. We do that all the time, creating moot hearings and moot setups of pre-hearings and things, just so we can work with it. Arbitration does not have to be a single hearing. They may be anywhere from 1 or 2 meetings to, dozens of meetings, dozens of hearings. It depends on the size of the case. So you may have a pre-hearing ODR. You may have an initial meet ODR. You may have a documentation review ODR conference. These are all absolutely expected in arbitration. So you may not be meeting one time, just like in court. A judge doesn't hear you one time. Counsel may meet with the judge a dozen times before the actual physical final hearing. Same thing happens in arbitration. So again, an arbitral coordinator really helps out a lot. You have your disclosures in the beginning, okay? That's all handled. You do your pre-hearing conference, especially if it's ad hoc, to set the final rules, the final guidelines that you're going to go by. You really have to check your contract because this is very specific. Parties have to agree to everything. Set your dates and times. When are you meeting for document review? When are you meeting for maybe another pre-hearing conference? When are you meeting for the finalization of witnesses if it's not done early on, or they have to get people together? When are you holding your first hearing? You have to share those dates and times. You also have to share your ODR link. If it's Zoom, you have to share that. It can't come from the arbitrator to one party. Again, if an arbitrator is sending an email, or an email is coming in from an arbitrator, it needs to have everybody tagged on it. So if the arbitrator sends something to the plaintiff, they need to send it as well to the defendant. Or if there's a third party involved, it also needs to go to the third party at the same time. and you need to instruct them. If they're replying, they need to reply all. Everybody gets the same communication. That's, again, where an arbitral coordinator helps, because everything going to them is for disbursement. The arbitral coordinator can bring it in and then send it back out to everybody else, and it keeps the arbitrator at arm's length. I'm just a big fan of it. You can pretty much see that with my presentation here. There has to be that disconnect. There are arbiters that just do things by themselves, and that's fine, but you have to really watch yourself and make sure that you're not having private communication. And especially emails, phone calls, they get real easy to have a private conversation. Coordinator opens up the hearing. That's what they do. Once they open it up, they set it up, everybody's there, they bring the arbiters in, and you hold the hearing. You just proceed with your arbitration only when all people are there. If not everybody's there, there's no sense to hold your arbitral hearing. And again, that's where a coordinator helps out greatly by limiting that factor that can affect your award. Because the last thing you want to get is you're holding a hearing and one of the parties is not there, or you're 20, 30 minutes into a hearing because they were late, they had a technical issue, or they couldn't get to their office due to traffic or whatever. You can't have 10, 15, 20, 30 minutes, an hour long, even sitting quietly in a room with one of the parties and you being the arbiter, especially if it's a single arbiter, not a panel, especially. Too much can be said, too many things can be made of it, and it's just best to just avoid the situation. There's just no way out. A judge has been put on a bench, whether they've been elected to a bench or appointed to a bench, and they are affirmed to have the ethics of not breaching that confidentiality and that ex parte, in other words, discussing too much information. An arbiter will never be looked at that way. An arbiter will always be looked at as suspicious because we're not been appointed to a bench. Okay, we're not a bench judge, no way, shape, form, or how. So it's always going to fall back on the arbiter did something wrong until proven otherwise. And if you'll keep that in your mindset, it'll go a long way setting as an arbiter. And that's the end of our presentation today. If there was any questions, I'm going to kind of get Chris back online here with us and see if we had any questions or anything, or if everything's good. If you want to email me any questions about arbitration or ethics or even mediation, I don't mind. My contact information is there on the screen, and as well as my email, and just send me any type of question you have, and I'll be glad to answer it, answer back to you. Or if it's an arbitration question that's specific, I'll have a coordinator get back with you.
Hey, Justin, Chris, we have one question on how do you become an NAR?
There's several different ways. You can, of course, if you've had any type of legal training, such as, for an attorney or LLM, these will prepare you for that. There are some organizations out there that do specific training for a NAR and will allow them to, teach them how an arbitration flows. One of the easiest ways is to get a little bit of CLE training or get any type of training through your bar associations. I mean, the minimum would be read a book on arbitration and understand how the flow is, but basically just understanding how the arbitration works, how you represent a party, how the flow goes, because you have motions in arbitration just as you do in a court hearing, and just simply understanding the flow, the path, the pattern. And once you understand the flow and how all that works, then just, put yourself out there and tell people you're a NAR and show them your credentials, that you understand how an arbitration works, you understand the rules, and you understand the functions of a NAR.
Okay, well, excellent, Justin. That was an excellent presentation, and I give you a round of applause for Justin, and thank you very much, and we'll look forward to seeing you on the panels on Friday.
All right, thank you. I look forward to Friday, and we'll be there, and we'll talk some more. Yep. Thank you, Chris.
Okay, recording's off. Good job.